Okay, I apologize, everybody. It's 10:01, and I'll go ahead and introduce our speaker. Jennifer Bezorgnia will be presenting on youth diversion today, and she is the court director for the city of Irving.
All right. Thank you, Tiffany. And good morning, everyone. Welcome to Youth Diversion. To help me understand better about the audience, there is going to be a small amount of participation asked just in the beginning. And then from there, I'll go through the presentation. And I definitely want to make sure that we have time for questions. This is your training, so I want to make sure that you leave here feeling more confident and feeling like you've gotten your questions answered. So to start us off, how many of you guys attended a TMCEC legislative update? All right, just a few. Not a problem, not a problem. How many of you attended the TMCEC regionals? And so you've gotten a preview of what this presentation looks like from a TMCEC perspective. Okay, couple, few, awesome. All right, there's going to be some repeated information. Honestly, though, this is more so the nuts and bolts of what we can expect as the clerical team that's supporting our judges, supporting our prosecutors, and what that needs to look like. So let's go ahead and get going. There we go. All right. As a reminder, we are all in this together. Nobody has done this before, and so we are all starting from the same place. So if nothing else, just remember that we are doing this together and we're starting from scratch. Utilize each other as a resource. Obviously, what we do best in the clerk world is we steal from each other. And so if you see something that looks good somewhere else and you feel like it's going to work for your community, take it and piece it together. I also want to point out, if you were not familiar with it, TMCEC does have an entire resource page dedicated to youth diversion. That address is listed on your screen, the www.tmcec.com/youth diversion. And as they gain more resources, they're updating that page. So it's evolving. As of right now, there's some great stuff out there. One, there's a bill summary. If you have not had a chance to go and actually read the bill summary and TMCEC commentary, I would certainly suggest doing that. It may seem overwhelming at first, but I promise you what they've done is they've allowed the flexibility in the bill to afford every community, no matter the size and no matter the resources that are readily available, an opportunity to make this work best for them. So I can really appreciate the thought that went into it, but it does make for a lengthy bill, but there is a purpose behind it being that lengthy. Also on the TMCEC resource page, there is a workflow. If you are more of a visual person and you like to see step by step what happens and if this, then that is going to be a great resource for you to refer to. In fact, if you have the ability to pull that up while we're going through this presentation, it may help you walk through it. I have a screenshot included just to kind of show you some of the pieces. But it is certainly something that for me, especially, I like to see step by step and the colors and things. So it's been a great resource for me. Lastly, they also have, how many of you guys are familiar with the TMCEC bench book? Whenever they used to have that out. Yeah, a few of you guys, and it was very step by step. This is what you do, and these are the statutory references that apply to each of those pieces. They've also made that available for youth diversion. So if you are more of a bench book type person, then know that that resource is out there for you as well. Lastly, as they start collecting examples of youth diversion bills or youth diversion plans that different communities are passing, they're going to be adding those to the website as well as references for everyone. So they should have small, medium, large. I think there's even going to be one that is from Lubbock County. So it's going to encompass everything within Lubbock County, which is really neat. I'm looking forward to seeing that regional plan. All in all, I just want to make sure that you guys are aware that that is a resource page available for you. Mark it as a favorite, refer to it often because it'll be updated often. Also, and it's like we hang out with attorneys all day or something. I do want to point out that this presentation obviously is my interpretation from a clerical perspective. I certainly suggest that if you have not already gotten your judge or your prosecutor, your city attorney involved, make sure that they are prime players in you setting up your youth diversion plan. Not only one is your judge going to be the one who is going to be adopting it and putting their name on it, but also because you want to make sure that they are interpreting it the same way that you're going to be implementing it. So make sure they are primary players in what you're doing. All right, now that my disclaimers are out of the way, let's talk about what we're going to hope to learn throughout the presentation today. We're going to describe the background of 3186, which is also called the Texas Youth Diversion and Early Intervention Act. We're going to identify requirements of the bill for municipal courts, and then we're going to hopefully understand the practical application and timeline established for the effective implementation of youth diversion. Bottom line up front, if you're the bluff type people, just know that the purpose of the bill, it aims to limit contact by juveniles with the juvenile justice system. It hopes to connect them with supportive services within the community and divert them from being in the juvenile justice system altogether. So I don't know if any of you are familiar with the Texas Supreme Court Chief Justice Hecht and the example that he gave as far as juveniles in the system, those who may have gotten charged with stealing an actual car. They're referred to a juvenile system that gives them a lot of access into services that address the underlying behavior. Whereas municipal courts, if let's say that same child steals a Matchbox car from a gas station, they're pushed through the criminal justice system and they're criminalized through the municipal courts, and they're not given the same type access to services automatically. And so I think the intention of the bill was more so to marry those systems. And so for us, that is something that we've never seen before, right? Because the way that we're going to process these and the way that we're going to track these is something totally different than anything that we've ever experienced. And so for us, it's going to take some time for us to understand and reprogram our minds from cases and processing cases and everything falling under Chapter 45 to really what this bill allows and how you want to implement it. Okay, so again, diversion from formal judicial processing. It's going to redirect youth who commit low-level offenses away from juvenile justice system and more so into your community-based interventions. For municipal courts, it's important to know that even if you don't currently have any juvenile cases filed with your court, this is still something that you need to adopt. So you still have to have a youth diversion plan in place, even if you don't have any juvenile interactions. And then lastly, the developmentally appropriate interventions. I know for many of us, we have probably already had judges who have started working towards community service that includes mentoring or counseling or job training or education type community service alternatives. And this just kind of codifies what is already being done in places to ensure that there's consistency and that those youth who are not being given these opportunities are also afforded those throughout the process. All right, laying the foundation. For clarification, there are two different types of diversion. There is judicial diversion, and judicial diversion is going to be mandatory. So no matter your size, no matter your location, you are going to have to adopt some form of judicial diversion. Now, the intermediate diversion, and we'll go into a lot of detail about what the differences are between these two. I just want to set the foundation for you to understand there are two different types. The intermediate diversion is the optional diversionary program type. Okay, so intermediate is more so if you have the resources and you have the ability to do things really prior to the case being filed, then that's going to be the route that you go. If you're not wanting to change how those cases or how that case information gets to you, then you're going to allow those cases to be filed in the court, and judicial diversion is going to be the method that you use in order to move forward. And again, we will touch on both of those, but that tends to be one of the questions that we get most frequently, is the difference between judicial diversion and intermediate diversion. And so by knowing up front that there are two different types, and we'll go into it, I just want to set that foundation. Also, the terms and the definitions that 3186 includes is many of the same things that we are already familiar with. When it talks about the definition of a child, when it talks about the definition of what a charge would be. Now, granted, this is an alleged charge, but all of that, that's going to be the same thing that we have already known. The only additions to those definitions that we may not be as familiar with is going to be diversion. And diversion itself is just a program that's trying to change the trajectory of what that juvenile is doing, and a service provider. Service providers can be any of the nonprofit organizations that are within your community or that you want to reach out to or partner with to help you facilitate part of whatever your youth diversion plan is going to be. Lastly, I really want everyone to focus on what you are currently doing for your deferred disposition. If you have a robust deferred disposition program with your judges who have lots of different conditions of deferred that include community service, or include things like teen court, or include things like counseling or school-based alternatives where you're working with your counselors at the schools, consider all of those right now. Look at what you're already doing and start there. There is no requirement for you to put something in place that works for you in the moment so that you're in compliance on January 1, and then pull that back if you want to make it more robust. Don't feel like it has to be this huge, elaborate thing in the beginning. Start with what you know. Start with what you're doing already with deferred disposition, what your judges are comfortable with, who you're already partnered with, and build it out from there. So at the end of the day, regardless of what your personal opinion is about youth diversion, we all have to do it. And so the nuts and bolts of getting down to doing it is really what you need to focus on, so that we can best assist our judges and our prosecutors in our cities in getting those going. So let's jump in. Here's a list of action items. For anyone who is a list maker and a checker offer like me, this is what I like to have, because I know from beginning to end, these are the things that I need to put in place. First and foremost, if you have not already renamed your local youth truancy prevention and diversion fund, as of January 1, that needed to be renamed to the local youth diversion fund. We'll touch on that a little bit in more detail, but as a slide to keep as a reference, if you want to, then this is a good one because it just gives your action items. Establish appropriate policies and procedures to address the case flow management of diverted youth. We're going to get into the nitty gritty of how is this information going to come to you? What are these things that you need to consider when it comes to logistics? What is the filing agencies that you're currently working with? Most of you, it's probably going to be your police departments or your schools that are sending referrals over. How are you going to get that information to you? And what are you going to do as far as case flow management going forward? Update your current policies and procedures to reflect any other mandatory changes impacting those specific offenses. Make sure that you dismiss, as of January 1, 2025, you dismiss any non-traffic related offenses alleged to have been committed by an eligible child. And that's really what we're going to be sticking to, is going into what the eligibility requirements are for youth to participate in youth diversion, and what you need to do to put in place. To specifically note, though, I capitalized non-traffic related offenses. Youth diversion will not go towards traffic related offenses for your juveniles. So if you have juveniles that you have traffic related offenses filed in your court, you are going to continue processing those just as you always have. Those will not change. This is only referencing any non-traffic related offenses for youth that are eligible. Okay. And that's beginning January 1, 2025. So to further that as well, if you have juveniles that have cases pending before January 1, 2025, you are going to process those just as you always have. So even if their appearance date, let's say the date of offense for that juvenile was December 31st of 2024, then they're going to go through the traditional processing that we have always done. It is only for the offense date of January 1, 2025 and forward. Okay. And then lastly, by January 21 or January 1, 2025, we want to make sure that we've adopted a local youth diversion plan detailing the strategies utilized to redirect youth before the effective date. And that effective date, again, you'll hear me say this over and over, January 1, 2025. All right. So back to that implementation timeline, if you like to see it pushed out in a visual mode, January 1, 2024, you heard me just mention, if you have not worked with your finance departments to rename that fund from the local truancy prevention and diversion fund, you need to do that. It is now the local youth diversion fund. And as a reminder, that is part of the local consolidated cost that we recently adopted. And in the past, the name was also the juvenile case manager fund. So we have all of these things that they are the same thing. It's almost like Prince. We're going to just get a symbol for it so we don't have to change the name anymore. Because I feel like we've changed it so many times. So it went from the Juvenile Case Manager Fund to the Local Truancy Prevention and Diversion Fund, and it is now just the Local Youth Diversion Fund, or the LYDF. Okay. Also, January 1, 2024 became an effective date for the legislature to expand the use of the Child Safety Fund. How many of you are funding your school crossing guard programs? By show of hands. Not too many of you. Either that or you don't know that you're doing it. If there is anything in excess from your child safety fund after funding a school crossing guard program, because that is a requirement that it be used first for that. If there's anything in excess, the excess can be used towards youth diversion beginning January 1, 2024. Interestingly enough, obviously, with youth diversion not starting until January 1, 2025, you probably won't have anything to use it for, but anything in excess of that can be used to that fund so that you can then start redirecting it to youth diversion January 1, 2025. All right, so now between this date today, August 22nd, 2024, and January 1, 2025, it is up to us to figure out what the heck we're supposed to do. So that's where we are. We're in the what the heck mode between now and January 1. Because beginning January 1, 2025, that is the deadline for municipal courts to implement a youth diversion plan. Additionally, for any of you that have graffiti offenses that are filed in your court, because, a couple legislative sessions ago, municipal courts started getting jurisdiction over those offenses that have the fine amount for the graffiti. Usually, I know in Irving, we have found that the value of that those graffiti offenses are greater than what we see in our court anyway, so it doesn't really impact us. And from what I've heard across the state, that's generally the same. But for any of you that do have those graffiti offenses, that $50 fine for those convictions can go towards youth diversion as well. And then lastly, as I mentioned, any non-traffic offenses committed by an eligible child on or after January 1 must be diverted under the new subchapter 45 of the Code of Criminal Procedure. Okay, so the general rule in eligibility. General rule says that if a child does not contest a charge that's filed, is eligible for diversion, and accepts the terms of a diversion agreement, then a charge may not be filed against that child, or if a charge has already been filed, the court shall dismiss the case. Okay? If the court dismisses that case, this is another thing that it's sometimes, the case itself is dismissed, but a separate referral, separate tracking, separate non-case case comes into play. And that's what you're going to start with youth deferral or with youth diversion. So the one definition that the bill did not give us was what we call these. We always have cases, right? And so do you call these non-case cases? Do you call these referrals? I think in some other places, I've heard a youth activity incident. They're going to call it a YAI. Whatever you want to call it, just recognize that it is not an actual case at the point that it's going through diversion. And even if it was originally a case because there was a case filed, that case is dismissed, and this separate youth diversion is in play until they either complete or they're unsuccessful. And we'll touch on that a little bit more in the future, but it is a whole separate instance than what it is when that case was filed. All right. In order for the child to be eligible to participate in youth diversion, they have to have been charged with a non-traffic Class C misdemeanor. They have to have not successfully completed a diversion program within 365 days. Now, to note, that 365 days is from the date that the agreement was entered. It is not from the date of offense. All right. So if someone committed an alleged offense January 1, and then they come in and they don't agree to youth diversion until January 31, then they're not eligible to participate in youth diversion again until January 31 of the following year. They didn't do us any favors in making it 365 days either, because it is not 12 months, it is 365 days. So in the event that you have a leap year or something, just recognize you are counting 365 days from the date of that agreement and not just an even 12 months. Also, if someone has participated in youth diversion ever in the past and they've been unsuccessful with that youth diversion, they are no longer eligible to participate in youth diversion ever again. All right. They are permanently excluded from eligibility for youth diversion. Also, your prosecutor needs to have a part in youth diversion. It doesn't necessarily need to be an active role in reviewing every youth diversion that comes into your court, but they need to have a say in how they're going to determine whether they're objecting to youth diversion or not, because the prosecutor, remember, these are cases that belong to the prosecutor. We want to make sure that that prosecutor still has their role. If that role or if that prosecutor deems the youth diversion inappropriate for whatever reason, they object to it, then that child is not eligible for youth diversion. All right. And a lot of our smaller municipalities that may not have a prosecutor readily accessible in order to make those decisions as they come in. I've heard that some prosecutors are going to be creating standing orders and they're going to make a determination. As long as it meets this, this, and this, then I'm okay with that child going through youth diversion. I've heard some say, okay, I'm going to be good with every offense that comes through except for any assault that includes domestic violence. If there's a DV assault type charge that comes in that's been allegedly committed by a juvenile, that I'm going to automatically object to that going through youth diversion. All of those things, that's going to be determined whenever you have some meetings with your prosecutor and your judge, how y'all want to move forward with it. And then whoever in your city attorney or whoever makes that interpretation as you move forward. So just know that that's part of the role that the prosecutor plays, is having the ability to object. Also, the child must accept the terms of the diversion agreement. And again, as we take off our actual chapter 45 statutory requirement hat and put on our youth diversion hat, your diversion agreement is going to be very, very similar to your deferral order, right? So as you're thinking of those, just recognize that those really mirror each other. So accepts the terms of the diversion agreement. The child has to agree to that, and the parent has to agree to that. So unfortunately, if the child agrees and the parent says, no, I don't want to have to do all that, then effectively that child is ineligible to participate. Okay. So the written consent from the child's parent or guardian obviously is part of what that requirement includes. All right. Moving on. The roles and responsibilities of each of these players that come in. You have us court clerks, right? Court clerks responsible for facilitating those stakeholder meetings. If you have not already started having a conversation with your judge, now is the time. Get direction from your judge. You may be assisting your judge in understanding how this works and what the requirements are. And then from there, find out what your judge's vision is, what your judge's direction is, and then start building that. You may have a judge who wants to be intimately involved with all of the details, and that's absolutely fine. You know your role and your relationship with your judge. You may have a judge that just says, I'm good with this. These are the deferral strategies, order things that we're already doing. Put a plan in place and let me review it. And I just want to see the draft prior to us putting it out there. Whatever level of involvement your judge is wanting, just make sure that you're having the conversations now so that you can facilitate what you need to before you have to put this in place. Also, there's going to be a new role of a youth diversion coordinator. It is up to the court administrator slash the judge, based on the direction of the judge, who to assign those duties and responsibilities to. Also, obviously, just like we always do, we ensure ongoing compliance with legislative requirements. We know that our legislature, as much as they would like to get it perfect the first time, that is not always the case. And so with this being such a new program and new requirement, chances are that in this next legislative session, you may see some changes come down the road. My expectation is probably going to be that we're going to see some reporting requirement differences, because as of right now, there are no true reporting requirements other than keeping some statistical data. But obviously, we as clerks, we need to keep up with whatever changes come down the pike when it comes to the legislature. We also need to make sure that we docket non-adversarial hearings. We'll talk more about what a non-adversarial hearing is, but as needed, make sure that we have room in our dockets for that, and then appropriately maintain diversion records and statistics. Everything has to be kept completely separate from any of the regular cases that we're keeping, right? Because we have all of these things that we have to do, OCA, we have record retention policies and requirements from the Texas State Library. That's going to be traditional cases. Youth diversion has different requirements. So while we don't want to go backwards, we don't want to duplicate our efforts. We're not wanting to go from having electronic records and images to pulling out a drawer and having to keep these all filed physically. So we want to make sure that as we're building this from the ground up, we are taking the things that we're already doing and moving forward and not going backward. I know that's one of the main goals in our court as we're pushing this into place. Our judges, what do we need to expect from our judges? Our judges need to make the determination, are you going to be an intermediate program type? Are you going to stick to the judicial diversion type only? What works best for you? What are the appropriate diversion strategies that you guys want to employ as part of your youth diversion plan? And again, I mentioned being part of drafting that plan or just approving it, whichever your judge wants, and then presiding over those non-adversarial hearings resulting from diversion. One of the things that I want to point out too is with these two different models, the intermediate diversion gives your court an opportunity for the judge not to be included at all. There may be instances if you're participating in intermediate diversion where that judge does not have any interaction with the juvenile throughout the entire process. If they go through the youth diversion and they're successful and everything is exactly as it should be, they may have never had an interaction with the juvenile. If the juvenile goes through intermediate diversion and they're unsuccessful, then that may be the very first time that your judge is having interaction with that juvenile on the back end to find out why they have not complied with the youth diversion that was put in place. Make sure that as you're determining whether you want an intermediate diversion program or a judicial diversion program, that your judge recognizes what part those both play. I know as we've traveled across the state in talking with some of the different judges, and them trying to understand too what their role is going to be, it concerned them a little bit if they were going to be doing the intermediate, that they would not have an opportunity to interact with this juvenile at any time. And so they preferred, because of that, to continue to implement the judicial diversion. That way they still had the initial appearance where they're talking with that juvenile and the juvenile's parent up front, and then dismissing that case before they went through the intervention part of the program. So make sure that your judges are aware of that. Also recognize that the diversion strategies, as I mentioned, we'll go into some more of that later on. Your diversion strategies are currently your conditions of deferred. So as you're talking to your judges and you're trying to assist them in recognizing which diversion strategies, start off with a list of the conditions that they generally give for juveniles right now anyway. If you have a judge who really likes giving out essay requirements or community service requirements, all of those things can still be implemented into your youth diversion plan. You just relabel those as strategies as opposed to conditions of deferred. Okay. All right, your prosecutors. We kind of talked a little bit about this already, but remember, your prosecutors, if appropriate, they can object to a child's participation in diversion. They also need to make a determination if that child is unsuccessful in the youth diversion process. Do they want to refile that case? And I say refile because obviously if we have the mandatory judicial diversion, the original case was filed, it was dismissed. All right. They go through diversion and they're unsuccessful with diversion. Now it's up to the prosecutor. Do we refile that original case and let that case go through the process as it normally would? Or does that child just get deemed ineligible for anything going forward? I say all of that to remind you that the case doesn't require the court to refile it. It is completely up to the prosecutor because it is still the prosecutor's case as to whether or not they want to refile that case if that youth is unsuccessful. Also, make sure that they have a voice in drafting the court's youth diversion plan. As I mentioned, if you don't have access to your prosecutor readily, then they may not want an active role in drafting your youth diversion plan, but at least extend that offer so that you can ensure that they had a part to play if they wanted a part to play in drafting this plan. And then, as I mentioned, if they have standing orders or processing guidelines to assist with case flow management, get those put in place. That way you don't have to refer to them every time that you have one of these come across your desk. Juveniles and the families. We already talked about what those eligibility requirements look like, but what do we expect from the juveniles and the families while they're participating in youth diversion? Obviously, they need to appear for an intake process, and that intake process, depending on which method, the intermediate or the judicial, those may look differently. Your intake process is wherever it is that your youth diversion coordinator schedules that. Make sure they come in for that, complete requirements described in the youth diversion agreement. So they're agreeing to them up front anyway. They understand what the expectation is. They need to be following through with those expectations. Maintain communication with your YDC or your youth diversion coordinator through the duration of youth diversion. And then in the event that they are not complying with what they're supposed to according to the youth diversion agreement, then they need to participate in that non-adversarial hearing that comes thereafter, so that they can explain to the judge why they have not been able to comply with youth diversion. In continuing our roles and responsibility, you've heard me talk about a youth diversion coordinator. So that is a new definition. That's a new role that the bill mentions. But let me tell you that it is very general in who that person can be. It does not give any training requirements, and it says that the court can determine whoever it is that they want that person to be for their court. So as the court admin, you can be the youth diversion coordinator. As the court clerk, you can be the youth diversion coordinator. As a juvenile case manager, if you already have the duties of a juvenile case manager and your court thinks that the youth diversion coordinator responsibilities is a natural progression, then absolutely your JCM now becomes your youth diversion coordinator, and they're doing the same thing. It also states, though, that they don't even have to be employed by the court. If you have a third party or a nonprofit organization that you want to utilize as your youth diversion coordinator, then they are absolutely eligible to do that. I've heard in other parts of the state that possibly using the Boys and Girls Club, or possibly utilizing your school counselors, since they're already intimately familiar with some of these kiddos and maybe what they're going through, maybe utilizing them as a youth diversion coordinator. The youth diversion coordinator is going to be responsible for not only employing the diversion strategies as directed by the judge in the plan, but they're also going to be required to monitor the progress throughout the duration of the diversion, and ensuring that all records are either maintained or forwarded to the court for maintenance. I know in Irving, we are going to be utilizing our JCMs. If you don't have JCMs, I've heard in other places they feel more comfortable with this role being given to someone in the court so that they have more control and they have more access to what's happening through the duration of youth diversion. But that's totally up to you. The bill really expands those definitions to include anyone that you can possibly imagine. So be aware of that, and then just make a determination on who you want to be that YDC for your court and who works best for you. Your external and nonprofit organizations and partner agencies. The bill also allows for really robust partnerships. For those of you, how many of you actually have a JCM that you're employing right now? Just a few of you. So for the rest of you, that means that you've been collecting this money from the local court costs and it's been sitting in a fund and you've not been able to do anything with it. And so one, now you get to go to your finance department and say, yay, we actually have something that we can spend this on. And two, you're going to have a pot of money. If it's not something, if juveniles aren't something that you do frequently, this may be an opportunity to work with them and say, hey, we want to partner with you, or we want to partner with a sister city. You can use a JCM, maybe from the city next door, if that works for you. And then you can say, we'll supplement part of their salary if they also help us with our youth diversion. It expands opportunities for partnerships in that way, through your nonprofits, as I mentioned. If you're utilizing nonprofits as part of your diversion strategies themselves, my suggestion would be to get something in writing, something like an MOU or a memorandum of understanding. An example of an MOU is also available on TMCEC's website. Make sure that you put in writing exactly what you're willing to contribute, but what the expectation is of those partnership agencies at the time that you're drafting this too. Let's keep going. All right. So I mentioned that the workflow that TMCEC had drafted was on their website, and I said that I had a copy of it. This is kind of what that looks like. The point, though, to putting this out there was more so because I want everyone to know that throughout the duration, if that case is filed in your court, actually filed in your court, then there is a caveat that preserves the right to trial for that juvenile. So if that juvenile has actually been charged with the offense and that juvenile wants to plead not guilty to that offense, they have every right to do that, and they'll continue to have the right to do that. So we do need to move forward with either a bench trial or jury trial based on that plea of not guilty. This is where it gets a little crazy, so stick with me. After that juvenile pleads not guilty and they go through the trial, if the judge sees that there's going to be an imminent finding of guilt, that ultimately there will be a judgment entered against that juvenile, they stop what's happening and they offer youth diversion. If that child agrees at that point to participate in youth diversion and they still meet all of the eligibility requirements that we've already discussed, that trial stops, there is no judgment entered, and that youth goes through youth diversion. That case is dismissed and it's pushed through the process of youth diversion. Okay. How many of you have a plethora of juvenile trials, though, that you currently hold? Yeah, exactly. We very, very rarely have them in Irving as well. So I'm not sure that this is going to be something that we have to worry about frequently, but it is something that you need to be aware of in the event that that case is filed. Okay, so if that case is filed, definitely make sure they know they can still plead not guilty, because obviously if they plead not guilty and there is a finding of not guilty through the trial process, whether it's a jury trial or bench trial, then we want to make sure that that's noted for the record as well. Okay. All right. Okay, so now we've gotten into intermediate versus judicial. The intermediate diversion program, this will happen before a case is filed. The things that you have to think about when it comes to intermediate diversion: do you have the ability to change how case information gets to you? Do you have the relationship, whether it's with your police department or with your prosecutor's office if they're going through the referral process through the schools, because we can't have citations directly from the schools, or your SROs, whoever it is that's normally filing your juvenile information. Do you have the ability to change how that information is getting to you? If you don't, then intermediate diversion may not be something that you can employ in your court at the moment. If you do, though, and you can intercept that information prior to it actually becoming a case, then you can employ intermediate diversion before the case is filed. I'll put a note out there, and this is something that you'll need to talk to your judge and find out the direction from your judge or your city attorney's office. In my opinion, for electronic citations that come over, I don't know how many of you utilize electronic citations or even the citation books themselves. If a citation is numbered and it is filed with you, I don't want the responsibility of clerks making discretionary decisions on when something is filed and when something is not. So if something comes to our court and it is on a citation or it has been filed electronically through a citation, we are going to consider that a filed case. All right. If you have not already started reaching out to your case management software teams, now is also the time to do that. If they have something in place that will allow you to have that case information come through, but not be actually filed, or have a mechanism where that case is not considered filed, then absolutely you can make that. You can use that when determining whether your judge and your prosecutor and your city attorney think that that case is filed and how you want that information to get to you. If you have not already had those conversations, reach out now. I can tell you that some of the big ones, the biggest one in general that the majority of us have, they do already have a youth diversion module that they are planning to employ. There's some worksheets and some things that you need to put in place prior to having it added to your case management system. And you want to make sure that you step through those, because maybe not all of it's going to work for you. If you don't have a large software, reach out to the development team of whatever software it is that you have, so that you can be a part of what you want it to look like. Because you want to be able to use the same scanning, the same repository. If you have a place that you're keeping all of your electronic records, you want to still be able to keep your electronic records in the same place, but you don't want them commingled with the records of your actual cases. So as you step through all of this, the nitty-gritty of those logistical details, we as clerks need to be having those conversations with our case management software so that they can build it to what we need them to build it to. The other piece of that, I know, again, this is just with the largest one that I'm not going to mention, but I'm sure you all know what I'm talking about. There will be no cost associated with getting these changes because it's a legislative requirement. So if you reach out to your case management software, I would kind of push, it's a legislative requirement. You need to build the case management software to meet the needs of what we're legislatively required to do. So I'm going to step off of that platform and keep going. With intermediate diversion, you do specifically have to state in your plan that it's an intermediate diversion type program that you're utilizing. And the intake and interview guidelines are not determined by Chapter 45. I mentioned to you that there may be instances if you utilize intermediate diversion where your judge is not going to have any interaction with this juvenile or this juvenile's family. If you consider that we no longer have an initial appearance requirement because these don't fall under actual cases under Chapter 45, you could be doing your intake process. You could be applying your diversion strategies or having the juvenile and the juvenile's family commit to the diversion agreements with your youth diversion coordinators at a school. If you have the counselors that you're working with, you may be doing that there. And so they may never be setting foot into the municipal court building. Now, with intermediate diversion, it doesn't exclude the municipal court from being a place that you can do that. It just takes away the limitations of that. Also recognize that with intermediate diversion, because the case is never actually filed, there's not going to be any refiling mechanism if they're unsuccessful. You'll have to determine how you want that case to be filed originally, because there will never have been an initial case in the beginning. The process, though, itself, at the point that they're in the youth diversion program, is going to mirror judicial diversion exactly. All of your strategies can look the same. 180 days is the period that you have to participate in youth diversion. If you're successful, that referral is closed. You don't do anything else with it. If it's unsuccessful, you schedule the non-adversarial hearing. That is the same, regardless of whether you're doing intermediate diversion or judicial diversion. Also, as we move to judicial diversion, understand again that judicial diversion is in place after the case is filed. You have to dismiss that original case, and you'll still go through youth diversion the same way that you would in intermediate or judicial, but that original case, which did require the initial appearance, they do go before the judge as you make that determination on whether they're going to participate in youth diversion. All of that you still are required to do. Does everyone need a second for that to soak in? I know a lot of times this is where it goes, which one do we do? If you are unsure or you don't have any ideas right now on how to make an intermediate diversion program work, or you don't even know in your mind right now why you would want to do the intermediate diversion, then don't go there. Stick with judicial diversion. The judicial diversion is the mandatory requirement. Start there. And then in the future, if you feel like there's something that could be said for intermediate diversion, there is nothing that changes the requirement or that says you cannot pull that plan, adjust that plan, revise that plan, and push it back out there. Okay? All right. Moving on. All right, so the diversion outcomes. So you've had your juvenile and the child, they've agreed to do whatever strategy that you've chosen to employ. There's two different outcomes. You're either successful or you're unsuccessful. If you are successful, then that referral is closed. You hold on to the records only because you need those to make future eligibility determinations, but you don't do anything else with it. It just sits. All right. If they're unsuccessful, it's with diversion. That's when that non-adversarial hearing needs to be scheduled. The non-adversarial hearing is equivalent to what we would know with deferred. If someone doesn't follow through with conditions of deferred, what do? We schedule them for a show cause, right? So this is a show cause. That's not a show cause. It's a non-adversarial hearing. All right. When the judge presides over this non-adversarial hearing, the same things that they would normally have done for any of their conditions of deferred that are not being met, is still what they're going to make a determination of. So the judge can say, hey, why didn't you do what you were supposed to do? And the circumstances may allow for the judge to say, you know what? I think that in the spirit of what we were trying to achieve with this particular strategy, I'm going to say that this was a successful youth diversion. We're going to mark it as successful and be done. Or they may say, you know what? I hear you. Maybe you had some extenuating circumstances. I'm going to give you another 30 days. I'm going to give you another 60 days. As long as it doesn't last longer than 180 days, which is what we're used to now with deferred, then the judge can give them whatever extension the judge deems necessary. The judge can also say, you know what? I think that I want to change some of the things that you're required to do. Instead, we're going to employ this strategy, or we're going to do this instead. The judge definitely has the option to do that too. It is completely discretionary based on what the judge determines. The judge may say, you know what, you didn't do anything that you were supposed to do. I don't think that any amount of an extension is going to get you to do what you're supposed to do. This is an unsuccessful diversion. At that point, once the judge has determined that they are unsuccessful, there is a couple of things that the child can have done. One, we talked about this already. The prosecutor could choose to actually file or refile that case in the municipal court. In the event that that case is refiled, yes, you're thinking right, you're going to start all over again. So then they do go through initial appearance all over again. The judge sees them for that initial appearance all over again. The difference is now that they've been unsuccessful for diversion, they are never eligible to participate in diversion again. So then at that point, the judge can say, okay, I'm going to still offer you deferred if they want to. And maybe some of those conditions of deferred look very similar to the strategies if they want, or they can say, you know what, you already failed at youth diversion. I'm not going to offer deferred because I don't have to offer deferred. And you're going to do this instead. Whatever the judge would do normally goes through the regular process of Chapter 45, okay? You also never lose the option of transferring that case to CHINS. So children in need of supervision, how many of you guys are currently transferring to the county CHINS department that you work closely with? How many of you work closely with your county CHINS department? Yeah, us either. They do preserve the option for you to forward it to CHINS. You don't have to in any instance, but you still can. So if they were unsuccessful and you don't want to have jurisdiction over that case anymore, you can always forward it to CHINS. Although if your CHINS division of your county is anything like ours in Dallas County, then a lot of nothing is going to happen. So make that determination, whatever you choose to do forward from there, completely up to you. The unsuccessful finding, again, that's what triggers the case being refiled, and that is up to the prosecutor. If your prosecutor says, you know what, I don't want to go through this all over again, we're just going to mark it as unsuccessful, then that means that next time that child offends, if they do happen to offend again, then still they're ineligible for any youth diversion program going forward. Okay. All right. So now let's talk a lot about the youth diversion plan itself. The bill only has 3 musts included, all right? 1, the plan must be written and adopted by every municipal court, all right? We've gotten some questions. What does adopted mean? There is no formal adoption process. It does not need to go through your councils or your commissioner's court. Once your judge says this is what we're doing, then you've adopted the plan, okay? 2, it must be maintained on file for public inspection. That just means that your public has to have access to it in the event that they want to see it. I know for us in Irving, that means that we're going to put it up on our website and it is posted for public inspection, okay? Like I mentioned, it does not say anything about the amount of times that you can pull it down, revise it, and put it back up. It just says that the adopted version has to be available for public inspection. So that's going up on our website. And then lastly, it must describe the strategies used to implement youth diversion. It does not go into detail, though, about exactly what needs to be included with the description of these strategies. It doesn't say if it just needs to name them. So the level of detail that you choose to include in your youth diversion plan is completely up to you. Let's transition to the next slide because that's where some of the mays come in. The may part of what the bill includes says that the youth diversion plan may be devised for a county, municipality, or individual court. So you heard me talking earlier about partnering maybe with a sister city, or if you have a judge that is maybe the presiding judge in 5, 6 cities, 2 cities, 3 cities, and they want, for consistency's sake, for the courts that they preside over to have the same plan. Maybe you partner with them. If they're within the same area, maybe you're sharing resources. Maybe your JCM is the same all the way across for all of those, and you can help supplement the salaries or help supplement some of those strategies based on the funds that you've been keeping and unable to expend up to this point. All of that is completely up to you as you devise the plan. It's a may. You also may include agreements with service providers. So you heard me mention earlier those MOUs, the memorandums of understanding, or the MOAs, the memorandums of agreement. If you have those in place and you want to make those part of your plan so that the public can see them, then absolutely include them in there. You may have guidelines contained for disposition or diversion by law enforcement. How many of you guys know that your law enforcement agencies, maybe they facilitate a first offenders program for your class B or higher charges for juveniles? How many, anybody? No? Okay. Well, if you come to find that your law enforcement does participate in something like that, and you want to expand that program to be part of what your youth diversion plan includes, then absolutely you can do that according to this. It's a may, it's not a must. And then if you have any additional rules or policies that your judge feels is important to accompany the plan, include that here too. On that youth diversion resource page that I told you TMCEC has available, they have also added a panel discussion that includes judges, and then a clerical perspective, which happens to be myself. So sorry about that. But the judicial discussion on the level of information that they think is important to include, I thought was a very interesting portion of that panel. We had one judge whose perspective was the more general it is, the better it is, because it doesn't really limit how we facilitate it, and it may be more flexible for how we need to use it in our community. And then there was another judge there who said, no, I really think that the more detailed it is, the more that lends to consistency, which also allows the clerical team to know best how to implement and put it in place. So I'm going to have something very lengthy and detailed included with mine. That's how I want to go. And then there were others who said maybe somewhere in the middle is where you need to be. Either way, the mays and the musts are listed here. So make a determination on how you want that to look. And then if you do need to give some direction to your judges or some suggestions, maybe go out there and listen to those other judicial perspectives, which may give them some ideas on how they think it would best work for your community. Okay. All right. So let's go more so into the diversion agreement itself, and the form and what that needs to include. So they do give some guidelines on the diversion agreement. I will say too that TMCEC, I love TMCEC, they have done a great job at drafting a sample diversion agreement that has all of the musts based on what the bill requires. So all of the boilerplate language, all of the agreements, all of the things that has to be there, TMCEC has already drafted that for you. It may behoove you to go out there, get a copy of what their sample agreement is, and then update that to reflect what you need for your court. It has to be written though. It has to identify the parties and the responsibilities of the child and the parent. It's got to state what the objectives are. So what are you hoping to achieve with this? What does the child need to do? When does that child need to do it by? Any of the circumstances that you need to consider that has the community's best interest at heart, those need to be included. Obviously, you want that child and that parent leaving that intake process or that courtroom, knowing exactly what they need to do, by when they need to do it, and if there's anything in between that the expectation is going to be, whether it's checking in, maybe they need to check in and provide a grade report every week to your YDC or JCM, or whoever it is that's facilitating these, completely up to you. Any of the strategies under Article 45.305, which we'll talk about in just a second. And then you must provide a copy of that agreement to the child and the parent, obviously, to the court clerk, especially if the court clerk is not someone who's a part of that interaction at the time. So remember, if you're utilizing a third party, then that third party does need to provide a copy of that youth diversion agreement back to the court. Also, any person identified in the diversion plan, if there's a strategy that you're employing that's with a non-partner or a nonprofit agency that you're partnering with, make sure they get a copy of the agreement. That way they're aware of exactly what the expectations are of that child as well. The form itself, it's got to define the terms of the diversion, explain the possible outcomes and consequences. What happens if they're successful? What happens if they're unsuccessful? Also, it needs to emphasize that there is no admission of guilt. They're not entering a plea because remember, this is not a case. There is no case filed with you at the moment. Even if there was in the past, that case was dismissed, and this is the diversion that's a result of that dismissed case. So there is no admission of guilt. Describe the process for reviewing and monitoring compliance. So again, if you're supposed to be calling and checking in every week, make sure that they know that. Verification of the notice given, informing the child of their rights. Obviously, that's going to be a signature attestation, signed acknowledgement, acceptance of the terms by the child and the parent. All right. Now let's take a look at what some of those diversion strategies are that are listed to the far right. Take a second, read over those. All right, how many of you are not doing any of those as part of your deferral conditions right now? Exactly. I saw 0 hands come up. And I want to point out again, whatever you're doing for your deferreds, those are going to translate into what your strategies are. That doesn't mean necessarily that it has to be an exhaustive list right now, but this is where you start. Start with your conditions that your judges are already putting into place and label those as your strategies to start you off. Okay? That's teen court. Any school-related program, that means counseling, that means any self-improvement. If you've required that someone raise their grades through tutoring, all of those things are considered diversion strategies. Community-based service, I want to point that out. Community service itself is a result of a court order, right? The judge court orders someone to participate in community service. Well, if you don't have a case, you don't have a court order. But that doesn't mean that your judge can't say, okay, as one of our diversion strategies, it's going to be to participate in 15 hours of community-based service to this particular nonprofit. Let's say that you have we have Mission Arlington not too far away. They may say that one of the diversion strategies is 15 hours of service towards Mission Arlington or any nonprofit that achieves this. And so you've gotten away from there having to be a court order, but it's still completed what the court order results in whenever you have that community service component. Okay. Also, one more thing to mention, if you have your judges requiring any type of restitution, that is a result of a court order as well. And so restitution is something that you will not have as part of any of your diversion strategies. Okay. All right. It also says any other reasonable action determined. So the statute that lists what is considered a strategy is pretty extensive. And then it goes on to say anything else that would be a benefit to your community. So the same trend that we've kind of seen with judges having more discretionary ability to determine what community service looks like is kind of the same method that they followed whenever it comes to determining what the diversion strategies are going to be within your community. Also recognize that for our communities that maybe don't have as much access to nonprofit organizations directly there's nothing that limits the ability to do virtual classes or virtual skills training to help supplement some of those things that you may not have in your backyard or directly within your community. Okay. Just make sure that it's labeled as a strategy whenever you put that plan out. All right. All right. So some further consideration, your funding sources. One of the things that it mentions is that you can have a $50 per diversion required from the child and the parent. All right. It does say optional because if you don't want to charge that $50 fee, you don't have to. But it does not say, as a note, it does not say up to $50. So if you choose to charge that $50 per diversion, it is $50. Also recognize, and get ready for this, if you require, as part of your youth diversion agreement, that the $50 be paid and the child completes everything but the $50, they cannot be deemed unsuccessful. All right. So it cannot be held against them in determining their success through the diversion if they don't pay the $50. And if we back up and we think about that, remember right now, that fine through deferred, that's assessed to the child. Judges usually waive it because they recognize that the child doesn't have the means to pay for it. But this fee, the $50, is assessed to the parent. And so if the parent cannot pay it or does not pay it, the child cannot be held labeled unsuccessful in that diversion. Now, what you can do is you can hold your parent in contempt for not paying that $50, but that's a whole separate process, and that's something that your judge has to determine if they want to do. Your local consolidated court costs, that $5 that's going into your LYDF, that can be used to fund whatever strategies it is that you're currently employing. One thing that I want to point out too, and it is mislabeled on this slide, so please note when it comes to facilitation costs, which is a little further down the slide, it says ability to pass on to participant if included in the agreement. That is not the case. There is not the ability to pass on any of the costs that your strategies require to the participant. You will need to find a way to fund that or work with your partner agencies in facilitating that separately. Okay. So that $50, if you're going to apply that $50, that is the only amount that you can collect in order to offset the costs of youth diversion, in addition to that LYDF that we're already collecting. All right. As we go back to considering too how we're tracking these cases, remember there are no court costs applied to these because these are not actual cases. So whenever you're labeling these in your case management system, recognize that you need to have something set up so that you're able to track the alleged offense without applying court costs to that alleged offense. All right. Any of the fees that you collect, so let's say that you have that administrative fee, you've imposed that administrative fee, you've collected it, that allocation of that fee goes straight back into the LYDF or your local youth diversion fund. All right. Also recognize that for your case management software, you have to have a way to take the money for this fee. So if you're utilizing the big one, it would be like an admin fee, similar to your teen court fee. You just label it as where you want it to go, but you need to make sure that that's the only thing that you're collecting is just the admin fee and not any of the automatic work costs that would normally be associated with collections whenever you're taking payments. Right? All right, and then your case management software case flow and records. I've mentioned this too. Make sure there's a differentiation from your formal cases and how you're tracking the records for that. So however it is that you choose to do it, just make sure that it's not commingling with all of the records that you're keeping in your cases.
Jennifer, we are getting a couple of comments
Hey, a couple
in the chat
comments
that
and
they're having a hard time hearing. I don't know. It sounds like it's getting a little crackly on your side.
uh-oh. Let's see. I haven't changed anything.
That
I told
sounds
y'all
better.
earlier
So I don't
before we
know
start.
if something was hitting your,
That
for
sounds
me, it
better.
sounds a little better.
Here we go. Is that better?
Yes, I
Q,
think
we
so.
good? All
Let
right.
me,
Stop me again if something happens. I'm thinking maybe my wire is not working very well. All right. So moving on to the management of the program records, there are some big differences that you need to know when it comes to the youth diversion records. The biggest one, the one that's most noteworthy, is expunction. So currently we know that in the event that expunction occurs, the motion has to be instigated by the juvenile, right? At the point that they're eligible, they can submit the motion and the judge hears and makes the determination, and then the order goes out. That is not the case. There is no requirement for the juvenile to start the process. These records will automatically expunge on the child's 18th birthday. So you have to know that on the child's 18th birthday, they don't have to do anything. There's nothing required, no application or motion. We are automatically going to expunge those. Now, some of the questions that I've gotten, what if they're in the middle of doing a youth diversion at the time of their 18th birthday happens? My suggestion, wait until they've completed, whether they're successful or not, and then expunge after their youth diversion strategy is closed out. Remember, the purpose of having the records is strictly for the determination of eligibility. So at the point that that child becomes 18, then they're no longer eligible anyway because they're no longer a child. So you no longer need those records to determine if they've ever been successful or unsuccessful or tracking 365 days from success or not doing it at all. So all of those need to be automatically expunged. One other thing, though, the confidentiality portion, all of these are still confidential records. All right. So we are not going to release this information to anyone with the exception of statistical data. So we must maintain statistical data for each diversion strategy used, all the aggregate totals. We don't have to report anywhere yet, but we do need to collect it so that in the event that we're asked for, we can provide for it. All right. There is no requirement currently to submit anything to OCA as far as the youth diversion. Remember, though, for diversion by judge or the judicial diversion program, if that case was originally filed and you dismissed that case, that dismissal of the case, that's what you're going to report to OCA because it's still a dismissed case. So it's still going to fall within your monthly statistics that you're submitting to OCA. The subsequent youth diversion, though, that's a result of that dismissed case. You are not going to send any information to OCA about that whatsoever. All right. You just want a mechanism in place to be able to track your statistical data. Let's say that you have 20 kids that go through a youth diversion in a fiscal year. You want to be able to say what the success rate was for those 20 kids, which of those diversions were employed, and which of those diversion strategies were successful or unsuccessful. Okay. The retention and destruction, like I mentioned, it is basically to determine future program eligibility. So you don't need it for any other purpose. Confidentiality 450217 of the CCD, all of that stuff still applies. So really when it comes to the records itself, just make sure that you have the ability to reference back what those look like, and then you have a mechanism in place to automatically expunge whenever that 18th birthday or the time that the latest youth diversion strategy is complete. All right, so I know that's a ton of information, and I know that it's difficult to absorb all at once. And I know that as you sit and you go through it, you're going to come up with questions later if you don't already have them now. We have about 15 more minutes though, so I want to open the floor or the chat. I'm sure, Tiff, you may have gotten some questions through the duration. we can
Ye-
start there and then
yes, I
go from
did.
there.
So we did get some questions in the chat. I did want to make another quick comment. Whenever you turn, it seems that it crackles. So, but if you talk directly kind of into the mic, then it seems to be very clear. And so we were still getting some comments that it was a little crackly at the last few slides. So one of the questions we got it a
Okay,
couple of times. Will they receive a copy of the presentation? They wanted the printed materials for this.
absolutely, yeah. Tiff, I think you have all the participants.
Yes. Yes, I do
Okay,
have a list
so
of all
I'll
the
forward
participants here.
this to you.
Okay.
Perfect, yeah, or you can forward those to me and I'm happy to send that out so that you guys have my contact information. It's also listed here for you. That's my email address and that's my desk line. If you want to reach out and ask, I will absolutely help with as much as I can. I can tell you though that I am sometimes slow to respond or slow to get back to you, but don't give up on me. I promise I will make it happen.
We had about 4 other questions in the chat that I compiled here. So this one here for the intake process, there are times even now when we are not able to get in touch with the defendant or the parents. How does that affect their eligibility for youth diversion? Like if they're trying to do it, I guess, on the intake process on the front end of receiving the cases.
Yeah, that's a great question. So in Irving, we have made a determination. It's going to be an internal policy that you make with your judge and your prosecutor. We're going to set for an intake. If they miss that initial intake, then we're going to reset one time. Usually it'll be based on 30-day increments. If they miss that second intake, then we're going to file the case. Now, that doesn't mean, though, after we file the case, that they may not still end up going through youth diversion, but it'll be the judicial diversion as opposed to the intermediate diversion that we're then employing at that point.
And the next question we got, if you are a 2-person court with meaning 2 clerks will both take on the role of youth diversion coordinator or just the senior court clerk, was the question we got.
That again is completely up to you if you want to share those duties and responsibilities and then you want to supplement salaries from that JCM fund or the youth diversion fund based on the percentage of the cases that each of you are processing. I think that's a conversation that you should probably have with your city attorney and get the blessing from there. But absolutely, it doesn't require that it be one particular person. We're going to be splitting it between our 2 JCMs that are full-time.
Next question we got, if they are going to be forwarded to the CHINS department or in our area, for example, it's called Juvenile Probation Office, do they get filed first so that they can be transferred if you are transferring cases to the CHINS?
Right. So remember that it's only upon it's the unsuccessful note of the diversion after that non-adversarial hearing. So that's a great point. Your prosecutor would have to say refile that case, and then at that point you would transfer it on because it does need to be an actual case whenever you transfer it.
Okay. And then if you wanted to implement the alcohol and drug testing, and being that assumingly the cost will fall on the city as the cost can't be assessed on the cases, can you use the funds in the youth diversion fund or the JCM fund to offset those costs?
Absolutely. That is, that fund can be used for any of your strategies or anything resulting from those strategies. You just cannot push the cost of those tests onto the child or the child's family.
Next question, what fees are the juvenile case manager or youth diversion coordinator, what fees can you use to pay, to fund those roles? Besides, I guess, the youth diversion fund, assumingly, but
Outside of the local youth diversion fund, to fund the positions, that would probably fall within your general fund. There are some opportunities for grants to be received from the state through the Office of the Attorney General. I will say, though, that if you're going to go the route of applying for some of those funds through um, I think it's through the judge. I'll have to get that specifically, but it's going to state if you request those grant funds, it is a reimbursement. So your city will be required to pay that up front, pay your salaries up front, and then you'll have to go through the process of requesting reimbursement, which means you'll have to file a copy of your youth diversion plan with the state and make a determination on how that has impacted your community before they'll consider reimbursing you for the cost of that.
If someone, and I think this is kind of related, if someone within the court takes on the role of youth diversion coordinator, can the person be paid out of the proper funds as a youth diversion coordinator?
We have made the determination, yes. We believe that that is considered a cost of employing youth diversion, and so it would be a qualified expense that comes out of that fund. Again, so I suggest that you talk to your city attorney and make sure that they interpret that portion of the bill to read the same way. There's nothing specifically that prohibits it, but there's nothing that specifically authorizes it either. So we consider it an expense from the facilitation of the program.
And I just had one question kind of to follow up on I guess, the fund itself. You also mentioned the child safety fund can be used if you outside of the school crossing guard program. So that fund could potentially be used to cover costs. Okay.
So anything from the child safety fund that is in excess after paying for your school crossing guard program, all of the excess can be transferred to your local youth diversion fund to help offset the costs of facilitating your program.
And that is all the questions that I got in the chat. And so anybody that may have others out loud may ask those.
Great. Let's see. It doesn't look like then we have too many others. I know you guys, it's a lot of information, and it really does fundamentally change everything that we've known as far as case flow management and walking through step by step how you're going to do this. But we still have time. And remember, we're all doing it together. So ask questions, talk to other places. Again, if you're sharing a judge, call those sister cities and find out how they're planning to interpret that judge's vision and see if you can maybe mirror some of their policies, procedures, or how they're doing things. I think too, going forward, TMCEC is going to be offering throughout this next academic year more opportunities for youth diversion to be discussed, whether it's in workshop mode or maybe the best practices on implementation for what did you do that worked well? What did you do that didn't work well? And maybe having some roundtables. I'm not exactly sure what that's going to look like, but this is certainly not falling off of anybody's radar anytime soon. So as we try things and as it evolves, we'll keep coming together and talking about it. And, you know, if you try something and it doesn't work, just change it and pull your plan down, revise it, and go from there.
So we did get one more chat question here. If the cases will not be filed right away, if doing the judicial path, will they not be entered into the case management system?
So that's where I think it's a little bit of a scary slope. If you're receiving the citations in your court and you're choosing not to file them, that may be something that you're asking your clerks to make a discretionary decision on. And I would certainly get the guidance from your city attorney or the blessing from your judge. I wouldn't hold on to cases in that way. I think that that would be more so of what the intermediate diversion plan looks like. So if you receive the citation in the same way that you would any other citation, file it and go through the judicial diversion process. call that child in for the initial appearance or your, whatever your traditional intake is. Let your judge see them and then dismiss it past that point and allow them to go through diversion would be my suggestion. But certainly talk to your judge. And if your judge interprets that differently or sees it differently, then whatever it is that works best for your court, put that into place.